In a solemn courtroom in Florida, U.S., District Judge Robin Rosenberg delivered a ruling that captured the tension between justice, secrecy, and public interest. The decision, though technical in nature, rippled across a nation still haunted by the legacy of Jeffrey Epstein. "This court's hands are tied," Judge Rosenberg said, as she denied the government's request to release federal grand jury transcripts from 2005 and 2007. These transcripts, tied to a controversial chapter of Epstein's past, remain sealed, not because the court lacks will, but because legal precedent offers no path forward. The decision is distinct from ongoing matters in New York, where Epstein was indicted shortly before his death in 2019. That case remains under the jurisdiction of the Southern District of New York. But in Florida, where Epstein once struck a now infamous plea deal, the government's attempt to shed light on the past met the hard boundary of the law. Epstein, a wealthy financier with powerful connections, avoided federal charges in Florida nearly 2 decades ago, a decision that has fueled public outrage and scrutiny ever since. His 2008 plea deal allowed him to serve just over a year in a county jail, with generous work release privileges, despite multiple allegations of sexual abuse involving minors. The sealed grand jury proceedings from 2005 and 2007 have long been viewed as a potential window into what went wrong, or what was hidden, during those years. Federal prosecutors returned to the Florida courts, arguing that the secrecy surrounding those transcripts no longer served its intended purpose. They contended that time had eroded the rationale for confidentiality. The primary target of the investigation was dead. The public had a right to know. But Judge Rosenberg disagreed, not in spirit, but in law. She wrote that while the government's arguments were well-intentioned and acknowledged the extraordinary public interest in transparency, the law of the 11th Circuit left no room for maneuver. There are no exceptions, she noted plainly. The rules governing grand jury secrecy are strict, and they are binding. She added that the government had, effectively conceded, the limitations of the court's authority, acknowledging that precedent was against them. The 11th Circuit, which includes Florida, maintains one of the strictest interpretations of grand jury secrecy in the country. Unlike other circuits, it allows almost no discretion for judges to release sealed materials, even years after a case has closed. That means the 2005 and 2007 transcripts will stay locked away, for now. In contrast, proceedings in New York offer a glimmer of transparency. The Justice Department has a separate request pending in that district, where the legal framework may allow for more flexibility. It was in New York where Epstein was arrested again in 2019, on new federal charges of sex trafficking and conspiracy. His death in a Manhattan jail cell, ruled a suicide, ended his prosecution but not the public's demand for accountability. His longtime associate, Ghislaine Maxwell, was later tried and convicted in 2021 for aiding Epstein's crimes. She is serving a 20-year sentence in federal prison. But even with Maxwell behind bars, questions persist about who else knew, who else helped, and what law enforcement or prosecutors may have overlooked or suppressed. Many of those questions center around the early investigations in Palm Beach and the role federal grand juries played. What did witnesses say? What evidence was considered? Why did the case seemingly collapse into a lenient plea deal? None of those answers, at least for now, will come from the sealed transcripts. Judge Rosenberg's decision highlights the tension between the need for justice and the constraints of judicial procedure. It's a reminder that courts, bound by precedent, cannot always bend to public will, even when that will is grounded in a search for truth. Still, the ruling leaves many disappointed, especially advocates for Epstein's victims, who have long pushed for more transparency and acknowledgement. For survivors, sealed records feel like locked doors in a house of pain. Many hope that revisiting those grand jury records could lead to accountability for those still unnamed or shielded by legal maneuvering. Yet today, the court said no. Not because it lacks empathy, but because it lacks authority. In the years since Epstein's death, investigations have continued, documentaries have aired, and names have circulated in the media. But the grand jury, that solemn, secretive engine of federal prosecution, remains impenetrable. Its walls are thick, its contents sealed, and even in a world desperate for answers, Judge Rosenberg says the law offers no key. This ruling may not be the end of the effort, though. The Department of Justice could challenge the 11th Circuit's interpretation, or ask Congress to reform grand jury secrecy rules. Some legal experts believe that long-closed cases, particularly those involving high public interest, should be opened, not as a matter of curiosity, but of justice. For now, though, Florida remains a place where questions outnumber answers. Where victims wait, where transcripts sleep beneath the weight of federal seal, and where the law, at least for the moment, stands between the past and its reckoning.